All right, this is case number 21162250. This is Credit Acceptance Corporation versus initial J, last name is Robinson. The matter is before the court on the filing of a general civil complaint in this matter, alleging damages in excess of $10,000, $14,000. Your appearance at this time for plaintiff. Credit Acceptance, your appearance. All right, Ms. Finch, are you able to hear me?
Yes, I can hear you.
All right, looking for Credit Acceptance, counsel for Credit Acceptance. If you're on the Zoom, say something. All right, looking for last name Robinson. Last name Robinson. All right, that matter is set for 9:15 a.m. Neither side has indicated their appearance regarding this matter. I know that it was set on for status conference. It was set under my old Zoom number, but there should be direction to come to this number. I'll recall that matter again momentarily. The court now calls case number 21141478. This is Affiliated Diagnostics of Oakland versus City of Detroit. The matter is before the court, set on for looks like an adjourned hearing regarding this matter. Counsel for Affiliated, if you're on the Zoom, say something, sir.
Good morning, Your Honor. Attorney Ali Ajami appearing on behalf of Affiliated Diagnostics.
All right, and your P number, if you will, for the record, sir.
Yes, Your Honor. P84476.
All right, so good morning to you, sir. Let me see if I have somebody from the City of Detroit on this matter. Your appearance at this time, please.
Good morning, Your Honor. Stanley Okoli on behalf of the City of Detroit.
All right, and good morning to you, Mr. Okolia. So what's going on here? It looks like this is this case was started this year. Has there been some discovery? It looks like I set it for review, so the parties seem to be working on something here. Update me, Mr. John.
Yes, Your Honor. I believe so. This matter is resolved. We're just waiting for the City of Detroit's approval. And we are the non-moving party on this matter. So I believe defense counsel filed a motion to give more time to have the city council approve the settlement amount. Perhaps brother counsel can speak to what the status is of that review.
That's exactly right. We're just waiting for city council approval. On the average, it takes about 60 days. We haven't received that approval yet, but the case has really been resolved.
All right, thank you, sir. So I have a particular order that I enter sometimes, and it's simply an order that says that the case is conditionally dismissed, and that condition is upon a settlement pending resolution before the city council. If that resolution passes and the matter is resolved, the case remains dismissed. If not, the case will be reinstated. Does that meet with the requirements that both of you would expect in such a case?
That seems to be fine with us, Your Honor.
Yeah, that's fine by me, Your Honor.
All right, I will issue such an order. It will specifically provide that if approved by city council and payment if is made, that the case will be permanently dismissed.
Your Honor, if I may, would the court be fine with just adjourning this? So we reached this agreement back on September 16th of this year. Brother counsel had informed us that it takes about 30 to 60 days to get this approval. Would the court be fine with setting a control date or adjourning this matter 30 days? That way we can appear before the court. And then if we do get that approval, we can just call into the court and submit an order to the effect that this case has been resolved, and we can just kick it that way, rather than just dismissing it now and then having to go subsequently file a motion to reinstate in the event that city council does not approve it.
You made that real complicated, but I understand why. The fact of the matter is, with the order that I put together, it helps to get it off the docket, but it also simply provides that if something falls apart here, you would simply submit an order reopening the case. That's all that would have to happen. You submit an order reopening because of the nature of the order. The other thing that I want to communicate to both of you, that to the extent court issued such an order, all you need to do is come in on the Zoom on any given day. If something goes wrong, come in on the Zoom any given day and say, we need to speak with Judge Coleman. And I'll speak, but we'll get the case back moving the way it should be moving if for some reason something goes wrong. Okay.
Okay.
So that's the way, that's the only reason I would put that out there, because I know that, nobody wants the case quote unquote dismissed and then you got to go through a bunch of hoops to get something done. That's not the spirit of this, because the ideal here from both sides is that this case is settled. For some reason, the city council says no, then that means that the case gets opened right back up because both parties anticipated that it was settled. This is not a fight between the two of you anymore. It's just between whether or not the city council is going to go along with the agreement that has been followed. All right, so I'll send such an order, and I think both sides understand what the nature of the order is, and I'll make it clear enough. I plan to be here, but even if I'm not here, the other someone that is subsequent to me will understand that the nature of what this order is all about.
Thank you very much, Your Honor.
Thank you, Your Honor.
Me too.
I'm sorry, I was trying to talk to you.
Yeah, I got it as soon as I walk.
Okay. And I do have the files for you.
Got you. Not a problem. All right, this is case number 21-161-613. This is Preston Morgan versus Aisha Morgan. The matter is before the court on the filing of a general civil complaint. The answer has been filed with regard to this matter. We set the matter on for a pretrial conference in this regard. Your appearance for the plaintiff in this matter.
Preston Morgan.
All right, thank you, Mr. Morgan, and good morning to you, sir. For the defendant in this matter, your appearance at this time.
Yes, good morning, Your Honor. Darren Canfor, P44773, on behalf of the defendant, Aisha Morgan.
All right, thank you, counsel. Good morning to you as well. I see that this is a claim submitted before the court alleging damages of $14,000, in excess of $14,000. All right, have the parties talked in this matter to see if there's a way to get a long distance in a short time or not?
Yes, Your Honor, there is a bit of an issue. I realized that I was retained on this matter, I think back in early August, and then later on, I was retained by Mr. Morgan, not realizing it, on a separate landlord-tenant matter, which is scheduled the end of this month. So there is the possibility of a conflict with me not realizing it was the same Morgan that was the plaintiff in this case, that is now the plaintiff that was trying to retain me in a landlord-tenant matter unrelated to this case. So I may have to withdraw from one of these matters, although I haven't officially filed an appearance in the landlord-tenant matter yet for Mr. Morgan, and look at the ethics rules and make sure I don't want to do anything to violate conflict of interest rules or do anything ethically inappropriate here. So I'm going to look at that. I'm guessing there's a good possibility I'll have to withdraw from one of these matters to be able to proceed with the other one.
It certainly is. It certainly is sounding that way to me. So that becomes a bit of a challenge in this regard. So so are you? So in another matter, you have entered an appearance, but that would be in fact representing Mr. Morgan. Is that correct?
That's right. In a landlord-tenant matter, where he's trying to evict a tenant.
All right. And of course, in this matter, he would be suing your client.
Right. That's correct. As I was waiting, I spoke with Mr. Morgan earlier this morning when he saw my name on the Zoom, and then when he brought it up, I didn't realize it was the same Preston Morgan, because it is a fairly common name. I didn't realize it was the same person. And I was thinking I was retained on this matter first, so I can discuss with Mr. Morgan his options, and I'd certainly refund any money given to me on the landlord tenant case if he was amenable to that, to resolve the issue.
All right. Just one moment. All right. Well, the other thing here, Mr. Morgan, is that at least looking at this facially, looking at the complainant here, there's not a whole lot going on with this complaint. I don't see much of a cause of action, but we'll see what happens with this. So, counsel, you want to speak with Mr. Morgan in a breakout room? Is that what you wish to do?
Yeah, if I could do that, Judge, I guess that would be appreciated.
Yeah, and see which direction this is going to go in, and let's see if we can drill down on what's really going on here. It looks like this is a family member, and this is about moving out of a home, having done some installation of bathroom and things like that. I don't see where there would be the ability to have any right of collection.
Right, and I can point out, Judge, the defendant in this case is Mr. Morgan's mother.
All right, yeah, I mean, that happens. I've been a judge almost in excess of 29 years, so nothing is new under the sun. And so I understand that people have those kind of conflicts, but notwithstanding whether it's a family member or not, particularly this is relevant here, the complaint is style in this case, alleging some $14,000 in damages under those under the allegations that set forth. That's not. It's just it's just not enough on the face to really suggest anything that would put numbers in that realm. But you guys talk about it. I'll come back in. I will also. I'm gonna move to another case, but when you come back in, I'll come back to this one. So I'm sending this counsel, and I'm also sending you a notice, Mr. Morgan.
All right, thank you.
All right, the court now calls case number 21-16-0366, American Express National Bank versus Clara Flowers. The matter is before the court, settlement for a pretrial conference on today's date. I'm looking for counsel for American Express National Bank. Counsel for National Bank, American Express National Bank. If you're on, please say something at this time. I have counsel for Carla Flowers. Counsel for Carla Flowers. Right, the matter is set on for 9:45 a.m. Neither party has appeared. I will recall the matter one time before taking further action. All right, the court now calls case number 21-16-0739. Strike that 736 are the last three digits. This is Complete Imaging LLC versus City of Detroit. The matter is before the court, set on for a pretrial conference. Your appearance for Complete Imaging LLC, please. I know I have someone from the City of Detroit. Do I have someone from Complete Imaging Incorporated or LLC? All right, for the City of Detroit.
Sorry, is this Complete Imaging? I'm sorry, Your Honor, I was on mute.
Okay, thank you. Your appearance, Madam Counsel.
Dunya Dazi on behalf of the plaintiff, P75310.
All right, thank you, Ms. Bazzi. Good morning to you, ma'am. All right, for the City of Detroit, your appearance at this time, please.
Good morning.
Good morning, Your Honor. Michael Otten appearing on behalf of the City of Detroit, P81884.
All right, thank you, Mr. Otten. Mr. O'Cully, looks like you were going to appear on that one as well, huh?
Yeah, I think there's some confusion, but yeah, I'll let him speak.
All right, thank you, Council. Mr. Alden, did you give us your P number, Mr. Alden?
Yes, Your Honor, P81884.
All right, Ms. Bazey, did you put your P number on there?
I did.
Okay, good. Just want to make sure. It's got that. All right, so it looks like to me that this is, I took over this docket, so I have to make sure that whether this is the first time. So it looks like this is the first time up. The answer was filed in this matter in August. Have there been any discussions? What do you need to go forward with regard to this matter? Somebody talk to me.
Your Honor, we haven't had a chance to talk. It got set for first pretrial, like you said, in August, and so we haven't got any dates or discovery hasn't been opened. So at this point, we really just need a scheduling order put in place so that we can do discovery and see where we're at.
All right. So Ms. Bazey, how much do you think you need by way of discovery? I know for the city of Detroit, I'm asking basically the same kind of question. How much time do you think is a reasonable time?
Not much, Your Honor. I don't like to drag these cases on as long as I have the claim file. It's usually all I need. So 30 or 60 days, depending on whatever the city would prefer.
Do you think maybe, Mr. Alton, the 60-day calendar might be something that works pretty well?
Absolutely, Your Honor. 60 days would be great.
Your Honor, just to clarify my confusion here, is the matter number for this case 21-150640-GC?
No.
Oh, okay. So
I think that's the next case.
okay. Thank you.
I see what the confusion is. Yeah, I got one coming up. I think that's that particular number. Thank you, sir. All right, so I will set this matter on a 60-day calendar. That will set discovery cutoff at just one moment. So yeah, that's gonna put us at December I'll go ahead and put it December the 20th. And you'll have open discovery through that date. I'm also going to set that date as a final pretrial conference. And that'll give an opportunity to come in for the court to review any issues that might be pertinent that you would like to bring to the attention of the court. So December 20th is your control date regarding this matter to come back. That's going to be at 9:30 a.m. December 29, 9:30 a.m. We'll get an order from me in that regard. That order will also indicate that the court will hear motions on that day, 12/20, 21, and 9:30. I'll hear motions on that day, dispositive and otherwise, to the extent that either party has filed such a motion and provided at least 7 days notice to the opposing party, 7 days opportunity to respond to the motion. So if you file a motion, notwithstanding the court rules in this regard, the court order is, in this case, is that if you file your motion and allow the other side at least 7 days to respond to the motion, I will hear it on the final pretrial conference date. Now, if you don't have a motion that you file, you get to pretrial conference and you say, Judge, we just ended discovery and I want to file a motion, we'll set a date up for that. But if in the course of your journey, this is not a conclusion for future motions, but if in the course of your journey in discovery, you say, well, I need to raise that and I want to get it in front of the judge. As long as you file that motion and it gives at least 7 days for the other side to respond prior to the hearing date, then I'll hear that motion on the 20th of December. That's why I'm not giving you any other motion filing deadlines, motion dates, to exchange a witness list or anything like that. Now to deal with that, if you want to do any of that in this 60-day interim, that's fine. If not, then at the 60-day point, we'll see what the case is, and then we'll make decisions about where to go from there. But again, if you have a motion, it will be in the order that you could file that motion. Just make sure the other party has 7 days to respond to it, and then I'll hear it on the 20th. Right? All right. So 12/20/21. Discovery is in fact open, and you may participate in discovery through that particular date, and you'll get an order from me aligning the issues that I've indicated to you already. Okay. I wish you well. Good day to the two of you.
Thank you so much.
Thank you, Your Honor.
All right, the court at this time is calling case number 21-150-642. This is Image Therapeutic Care LLC versus City of Detroit. The matter is before the court on the settlement for a hearing. Counsel, your appearance regarding this matter.
Good morning, Your Honor. Stanley Okoli on behalf of the City of Detroit. P number is 777. Oh my God, I don't remember my P number. 77. I need to look that up. I'm sorry.
All right, not a problem, Mr. Okoli. That's up.
73722.
All right, sir.
I'm sorry, sir. What is it? What is this page number?
The P number. Go ahead, sir.
73722.
Okay, thank you.
So, Mr. Okoli, I'm looking for plaintiff's counsel. It looks like Ms. Batty, who was just here, is counsel on this matter as well.
Right. That's why I was so confused. We have we have scheduled a facilitation that's supposed to transpire on December the 15th.
All right. All right. So given that is the case, that's a positive thing, particularly where she's not counsel. This is no longer here. I'll just set it just beyond that date to see if you've got it worked out or if we need to do anything further. That makes sense to you, sir?
Yes, it does. Thank you, Your Honor.
All right. So she's coming back on the 20th. So I'm going to go ahead and set this over for that date as well, December 20th.
December 20th. Okay.
Yeah, December 20th, 9:30.
Thank you, Your Honor.
Okay, thank you, sir.
Have a good day, Judge.
All right, likewise to you, sir.
Do we have someone in the breakout room? Was that Mr. Okuli?
I think they already been there.
Oh.
Yeah, no, they're still talking.
Oh, okay.
So regarding credit acceptance versus J. Robinson settlement for scheduling conference, the court ordered both sides to appear regarding this matter. It appears that neither side has checked in on this case. Accordingly now, the matter will be dismissed where neither party appeared. Regarding the case 21-160-366, American Express National Bank versus Carla Flowers, no one appeared on that matter, although the matter is set on for a pretrial conference date on today's date at 9:45. Given that no one has appeared on that matter, that matter will be dismissed. Well, I've learned that, that both of you know how to operate the breakout and to make your way back. That much information I've gathered.
Got a little experience with that now.
All right, so, so back on the record regarding the subject 613, that's Morgan versus Morgan. Counsel, why don't you update me as best as you can? I know that there's a little bit of a conundrum that you described in this matter.
Yes, Your Honor. Thank you. I just spoke with Mr. Morgan in the breakout room regarding this case and the other landlord-tenant case I mentioned, which I had not filed an appearance yet. Mr. Morgan and I have agreed that I will no longer represent him on that landlord-tenant case since I was retained on your matter first. I will keep representing his mother, Aisha Morgan, on that case. And Mr. Morgan is going to seek to retain counsel. He said possibly in that case, but he would like to retain counsel in this case also. And I said I would have no objection to the court granting him some time if he wants to retain counsel in this case. And I stated I will refund his fee for the landlord-tenant case in whatever method he wants me to.
All right. Makes sense to you, Mr. Morgan, sir?
Yes, Your Honor.
All right. And so what I'll do then, in consideration of all the things that have been set forth on this record, I will go ahead and adjourn it for maybe 30 days to give opportunity for Mr. Morgan to obtain counsel to begin to approach and proceed with this matter. That makes sense to you, Mr. Morgan?
Yes, thank you, Your Honor.
All right. So that would mean I'd set it over for the 22nd of November 22nd. And I'll set that one at 9:30 a.m.
Perfect. Okay, thank you.
All right. So
And that would be that's by Zoom also, Judge?
Yeah, that is by Zoom. All right. And you probably had a Zoom address different from the address here. I'll send another notice out, but you should know for future references that the Zoom number here is 336. I should say 360-336-0000.
Okay.
So the middle numbers, they changed my courtroom, so the middle numbers you had 538 or something, but it should be 336 in the middle. 360-336-0000. And as I've indicated, you'll get a notice when the corrected address. Again, the date of that hearing is November 2nd, 2021 at 9:30 a.m.
Okay.
Okay. Thank you.
Thank you.
All right. Good day to both of you.
Thank you.
You too. Thank you.
Right, Madam Counsel, good morning to you.
Good morning, Your Honor.
All right. Which matter are you on? What's the last three digits on your phone?
The last three digits are 419. It's Farmers versus Kadeja Aaron Lippett.
Gotcha. All right. This is case number 21157419. This is Farmers Insurance Exchange versus Khadijah Lippett. The matter is before the court, set on for a status and scheduling conference on today's date. Your appearance for the record, counsel.
Good morning, Ashley Russett here on behalf of Plaintiff Farmers Insurance Exchange.
All right, your P number, if you will, for the record, counsel.
P82174.
All right, thank you. All right, I don't see Ms. Lippett on this Zoom. I'm going to give it a few minutes. It's 10:33. So we'll give it a few minutes, and I'll come right back to this matter.
Okay, sounds good.
That's the notice sent out for that date. It's adjourned for trial. Notation on file. It's just that the plaintiff wishes to.
Gotcha.
This is the adjourned final trial conference date on this one. The notations that their cases and facilitation is probably resolved. So, Ms. Russert, you went into the 538 courtroom and they directed you here, correct?
Correct, yes.
Yeah, it's been working pretty efficiently, although when they changed my courtroom, they told me that it was going to be an automatic prompter that was going to come up or something.
Oh,
And
no problem. I was a little confused when I saw people on the video chat in jail, but they got me sorted out.
And that particular courtroom, 5338, where I was, it has a lockup to it, a jail part. And that's why I had to give that courtroom up. I love the courtroom, but I had to give it up because, you know, we don't need to lock up too many people in civil, so.
Right. Thank goodness.
Then that particular courtroom is also a specialized docket. So not only are those criminal cases, those are the you know, sort of the worst of the worst criminal cases.
Oh man, maybe I should have stayed in. It could have gotten interesting.
It will get interesting over there for sure.
Wow. I do miss those days in law school. When I was in Lansing, I used to just pop into courtrooms and watch the where they start with the original evidence. I can't think, because I don't do criminal law. I'm trying to think of what it is right now. Kind of like pretrial hearing.
Yeah, preliminary and pretrial hearing.
Yes, preliminary. There it is. Examination.
Yeah. Oh yeah. Yeah, I've done a lot of them in my lifetime, both as a practitioner and as a judge. And so I tell people that one of the things that happens is that in the criminal justice system, you get to see the best of people and the worst of people, all in the
Yeah.
all in the same configuration, you know, the best and the worst.
That's so true. I just started volunteering at expungement events, and I mean, it's like the most happiest experience, you know? And every time I
Yes.
tell people that, I'm like, I don't know how to explain it. Besides, it's just people so excited to have their life completely changed all from one piece of paper that I help them file.
One piece of paper. And, so many of them, as are quite young, made foolish decisions and what have you. And then the thought that they weren't even thinking about the implications of something affecting you for the rest of your life, touching everything you do. And there was a level of probably, in some of those situations where some of that from this beginning is just unfair,
There's that too.
And so to be able to get to that point of gaining some kind of relief that gives you a chance to take a sigh of relief and say, wow, I can put that behind me now. It's big time.
Most of these people, I mean, their charges or their convictions were older than me,
Right.
and it's kept them from getting a job or employment or housing.
Yes. And that could only get worse in the economy that we have now because employers, once everything boots up, employers can be ultra selective. So, if you got 5 great people and you have 3 great positions, then of course, if 2 of them have a conviction from 20 years ago,
Right.
They don't get the job. It's you go to the other folks. So it's life changing. It really is. And so that's really gratifying work. Really gratifying.
It is. It was, I started doing it just once, and I actually made a couple friends there with the volunteer attorneys, which was nice to meet some colleagues. And now I'm like addicted. I've gone to like four events, and I have my own pro bono client, which I represent insurance companies, so I don't really usually have a real client around, so it's kind of fun.
Excellent. Wow. Well, it looks like you found your way here, but it looks like Lippitt is not finding, that person is not finding their way here. I did receive an answer, which was in many instances sort of a general denial. And then there's one place where they indicated they shouldn't countersuing and that they sustained medical injuries. I know that the nature of the complaint in this matter is that your client seeks to recover for payments made for some person that may have been injured or personal protection.
I will say, I think, like mostly people, I don't think Miss Lippitt understands the nature of this case because she's being sued as the uninsured owner of the motor vehicle. So it's kind of irrelevant whether she was injured or not. So, based on her answer alone, she admitted all of the relevant things to make my case. In all honesty, she admitted she owned the vehicle and it was uninsured, and the individual was injured. Of course, we don't have a scheduling order yet. So I was going to send her some discovery just to kind of confirm those facts. Not sure if she'll really be cooperating much in this suit because I haven't spoken to her myself personally. But I anticipate if she doesn't cooperate, I'll just eventually end up filing an MSD. So.
All right. Well, it seems to me I've given some time for her to come in, and we certainly advanced the notice. I'm just checking a couple things here.
Okay.
The address that she provided as of August the 23rd is the address that we directed everything to. That's an address on John C. Lodge in the city of Detroit, and everything was addressed. Correctly.
That's also where we served her with the complaint as well.
Thank you, Counsel. It appears now that the defendant has not appeared for a duly scheduled hearing. The court has provided sufficient notice of the same. That notice went out on August the 25th, so that's been in excess of 3 weeks ago. The defendant has not appeared and otherwise responded or defended as relates to this matter. for that reason, I believe that you move for entry of default at this time. Is that correct, Counsel?
Yes, Your Honor, I would appreciate entry of a default.
All right. The court will enter the default of the defendant in this matter based on the failure to appear and otherwise respond as duly ordered by the court. It's noticed. The court will allow for entry of judgment on that default and will sign the order upon presented to the court. You can email that order to my clerk. That would be,
Ray Martin.
I have a visiting clerk today, so. Right,
It's the
you want me to
same.
send it to you or send it to?
You can send it to me here. It's Brandy with a Y, dot Walton at 36 District.
Brandy with a Y, B-R-A-N-D-Y
Yes, dot
dot,
Walton, W-A-L-T-O-N.
dot Walton, W-A-L-T-O-N, at 36 District Court.
Sir.
District Court. District Court all spelled out?
Yeah, everything's spelled out, 36TH, District Court.
Okay, okay. And I'm sending you just the order for entry of default, correct? Or would you like me to also send in an order for default judgment? Or I can file a motion at a later time for that.
No, you would present your order as a default judgment.
Okay.
And would simply indicate on your judgment that the court entered its default or defendant did not appear, and the judgment is entered on that default.
All right, great.
All right.
Thank you so much.
Have a good day
Nice
to you.
to meet you.
Yeah, good talking with you. Keep up that good work out there.
Thank you. I'll see you around. Bye.
Absolutely.
Excuse me, Your Honor. May I ask them to finish for her CSR number?
Deborah? Deborah?
5702.
You say 5772?
No, 5702.
Okay, thank you, Deborah.
No problem.
That is she.
All right, this is case number 21-155-417. This is Jefferson Capital System versus Elizabeth Miller. The matter is before the court for a scheduling conference on today's date. That conference was set for 10:30 a.m. In the interim, the court has received a default judgment. That default judgment was in fact entered on the 30th of August. All right, so there's already a judgment entered in this case. So no one appeared on this file, but a judgment has already been entered. All right, Deborah, it looks like we're done for our morning document.
You said it looks like what, Judge?
So it looks like we're done for our morning document now.
Oh,
Glad-
yeah,
glad-
okay.